TrialSim is an AI-powered advocacy simulation platform. It puts law students and practicing attorneys in front of AI judicial panels, judges, and witnesses with real scenarios, real legal issues, real authorities, and it lets them argue. The bench interrupts, it presses. Witnesses don't say what you want them to say. It doesn't let you finish a sentence if you said something worth challenging. And the moment the session ends, the platform scores what just happened across 8 dimensions of performance and tells you exactly where you held your ground and where you didn't. I've tried over 50 bench trials as a practicing attorney, and somewhere around trial 30, I noticed the lawyers who struggled in the courtroom, they weren't underprepared on the law. They knew cases. What they hadn't done was stand in front of a judge who interrupts you, asks you a question you didn't anticipate, and waits to see if you fall apart. That's not a knowledge problem. It's a performance problem, and TrialSim is here to help you. Whether you are a law student, new attorney, seasoned attorney, or a professor, we're here for you, your firm, or your organization. I have stand in court and I've gotten the reps with real consequences. What if there was a better way? So come to the site if you want more information, and you can try out the app and sign up for free if you want to start getting your reps in. You can even try it before you sign up. I highly recommend so you can stay in touch. Here we have the student view, and we can see what class we're in. We could go down and see what assignments our instructor has assigned us. And click in. And so this is what it looks like when you come into your case. However, students can also either get to their assignments or practice around on their own by going to the scenario library. And we'll still do this simulation. It is in the Supreme Court of the United Kingdom. You can argue as the appellant or as the Secretary of State, which is the respondent. Here goes the question. We have our facts, which you should take notes on. We have our procedural posture, and then the issues presented. You can reserve time for rebuttals. However, we will not be showcasing the rebuttal today. We have 3 different judges. All of their voices are distinct, along with their personalities and the type of facts and legal issues they are concerned with. Now we begin. May it please the court. I appear here today representing the appellant Tariq Ibrahim. The respondent advances 2 grounds. First, the Secretary of State's policy of permitting detention beyond 12 months without mandatory automatic referral to a court or tribunal is incompatible with Article 5, Section 4 of the Convention, as incorporated by the Human Rights Act 1998. The policy is structurally deficient on its face. Second, and independently, the specific decision to continue.
Counsel, you describe the policy as structurally deficient on its face. Point me to the language in Article 5.4, or the Human Rights Act, that requires this court to impose a structural requirement of automatic referral.
Counsel, I take it you're conceding that bail is available under the current framework. Does that not undermine your entire premise of a structurally deficient system unable to provide speedy judicial review as Article 5.4 demands?
Your Honor, Mr. Ibrahim is a 34-year-old Somali national. He was detained at Harmonsworth Immigration Removal Center for 22 months. For 17 of those months, deportation was impossible. The Somali embassy would not issue travel documents. There was nowhere to send him. The Secretary of State knew this, and yet detention continued. At month 14, the Home Office reviewed his case. The review concluded deportation was imminent and detention proportionate. It did not mention the medical report that had been commissioned, disclosed to the Home Office, and was sitting in Mr. Ibrahim's file. A report that assessed him as highly vulnerable and identified his prolonged detention as a direct cause and factor in his clinically diagnosed anxiety disorder. The Secretary of State's own inspector later criticized that review as a template response, not an individual assessment. So, that is why the respondent advances on 2 grounds.
Counsel, you just described the month 14 review as a template response. which failed to consider crucial medical evidence. Are you conceding that if the review had been individualized and had considered that evidence, the detention would have been lawful at month 14?
And here is the score. Not so great, got a 5.1 out of 10. We had issue directly answering the questions. We did satisfy one judge, but two judges were still waiting for us to meet their basis. And it gives you insight into them. It gives us our key moments with direct quotes from our own argument. It tells us where we left points. And it also tells us where we can improve most before our next round or trial. And again, it gives you a little bit more detail, especially when it shouts out the laws and the arguments that would have really helped us in this simulation. You can drop down the facts again. And it also really lays out all of the laws that could have been used for either side as well. You can even download it as a PDF for your own records, or if you need to send it to your professor for him to. Here we have the instructor or professor view of their teaching dashboard. And if they have more than one class, they'd be here for them to switch through. We've done all the setup. You can invite your students by creating a link that you send to them or bulk import through CSV file, right? You also can export this information in a CSV if you need export for grades or something like that. And here's our class. And so the student demonstration we did was under this student. She's performing best in the class and is telling us her trends and average score. You have everyone here. Then you can go to assignments and you can assign these things. You can pick a scenario, right? So you might pick Blackwell v. Technova. And it shows us what current assignments we have, right? And so this is what we just did, and it was assigned. And then we have analytics of the class, where this tells you how your students are doing, how many you have, how many sessions they're doing, etc., what they're practicing, what they aren't, right? It tells us who's performing best. No one needs a lot of support right now. It gives us some insight. And the instructor can also go through scenarios just like students if they want to test them or check for specific scenarios, or even if a professor wants their own fact patterns in TrialSim, we can make that happen.